Hi, this is Celestial Morrison, and I'm going to read to you the entire form that Dave Jose was talking about in this video. He got it written out for you. He did it for you. Any of you that have children that have been taken away from you and they were taken unlawfully, any of you that want to be safe from this ever happening to you, because we are all in danger when there are people out there that do things that are supposed to be legal, but if you really look into it, they are very much unlawful to do. So here I'm going to read the notice for you, and this poster here was done by Leanne S. So I'm just going to read from beginning to end. Here goes. The People's Notice to the Supreme Court and Jim Jordan. We the people have assembled and wish for Jim Jordan, the whole of the legislature, and the Supreme Court officers, to declare whether the process of taking children in return for federal funds and force adopting them has historical powers from the time of the American Revolution and under the common law. The People's Notice to the Supreme Court and Jim Jordan. Notice to agent is notice to principal, and notice to principal is notice to agent. I, one of the people, open parentheses, as seen in the 50 state constitutions, close parentheses, do present you with this notice that you, your agents, and your colleagues may provide due care. Please take notice that the people have assembled and consulted for their common good and have taken joy in the work of the Supreme Court to affirm historical and common rights, open parentheses, as derivative of the common law, close parentheses, and not according to the pretended legislation of public servants. Public servants wish to declare rights that are guaranteed in the state and federal constitution as objects that can be discarded once they have taken office. Please see the text from the one recent opinion of the Supreme Court below. Today, this is open quote, today, we decline to adopt that two-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's, open quote, unqualified command, close quote. Konigsberg versus State Bar of California, 366 U.S. 36, 50, N. 10, in parentheses 1961.3, close quote. Please take notice that the people understand that legislative tribunals have been used based on the Social Security Act of 1935 and following amendments to establish an idea that the state and local governments and private actors have the authority to take children without the common law and jury of peers, as is required to remove life liberty, or property based on, open quote, presumed public government compelling interest, close quote. They have adopted them to other families, open parentheses, and actually receive federal funds in partnerships to do so, close parentheses, without historical basis or common law practice, showing authority to do so. Please see evidence below. Black's Law 5th edition, adoption. Legal process pursuant to state statute in which a child's legal rights and duties toward his natural parents are terminated, and similar rights and duties toward his adoptive parents are substituted. To take into one's family the child of another and give him or her the rights, privileges, and duties of a child and heir. The procedure is entirely statutory and has no historical basis in common law. Most adoptions are through agency placements. It is my wish for Jim Jordan, the whole of the legislature, and the Supreme Court officers to declare whether the process of taking children in return for federal funds and force adopting them has historical powers from the time of the American Revolution and under the common law. Please indicate your conclusion in light of the above Black's Law 5th edition definition, which states it has no historical basis in common law. Please take further notice that as trustees of the people, you swore by oath to protect the rights of the people. Therefore, it is my wish for you to make public statements about this issue and for the Supreme Court to declare that this practice is not in accordance with the historical tradition of this great nation. Please respond to this notice within 14 business days, as this is a matter of necessity of people. As trustees, you are not allowed to let this nation's people suffer while trustees sit in silence. This notice is sent to you in the love of Christ and in peace. Now, when you click on this JOT form, you're going to have a space to put your full name. Put the entire Christian name, your full name, first, middle, and last. Then you autograph. Even though right here it says sign here, but it's really you autograph. Because that's what the people do. They autograph, not sign. And here you put the date. Here you put your email so that we can send you, or the machine can send you your copy that you have autographed this notice. And then here you can click right here and it'll show you the recipient list. You can also preview the PDF. Then you click submit and it will be done. And you will have it all ready. It'll come to you. It'll give you a box where you can check. Also, you can download it onto your computer and you can also have it sent to your email. All right, this is it. This is what you need to do if you are in agreement with this. If you want to protect your children from being taken without authoritative law, even though they send people like police officers and social workers and judges sign documentation, we have discovered and we have proof, as you have seen, we have proof that is not the true law. That is not what should be done, and it is wrong, and it will stop now.